Hello and welcome to this 5SAH webinar discussion between myself and Georgia Beatty. My name is Ben Keith and I'm a barrister. I specialise in extradition, immigration and Interpol Red Notices. George, would you like to introduce yourself?
My name is Georgia Beatty. I'm a barrister practising in crime and extradition.
Obviously, due to the lockdown, we're in our separate home offices. But Georgia recently wrote an article on the Anne Sacoolas extradition case and the recent issuing of an Interpol Red Notice in that case. And I thought it would be interesting to discuss the complexities of that case, in particular the issues surrounding the Interpol Red Notice and diplomatic immunity. But to sort of try and set the scene of that, the Anne Sacoolas case was obviously the tragic accident in which Harry Dunn was killed in a car accident, and it's alleged that Anne Sacoolas, the US citizen, was at the wheel of that car. She then left the United Kingdom and is back in the United States, and there has been a lot of discussion about whether or not she had diplomatic immunity at the time and still has diplomatic immunity in relation to that car accident. The Crown Prosecution Service, as far as we understand, have charged her. They've requested extradition from the United States, which has been refused. And last week, there was more press coverage, firstly from the mother of Harry Dunn, who wrote a piece in the Washington Post, imploring Ms. Sacoolas to return to the United Kingdom to face justice. And also, we understand, an Interpol Red Notice was issued. Now, the Interpol Red Notice is an additional extradition request, essentially outside of the UK to US extradition process. And so the idea is that if Ms. Sacoolas were to leave the United States, go to a third country, she could be arrested on the Interpol Red Notice and extradited to the United Kingdom to face charges for what we think is death by careless or death by dangerous driving. But the really interesting and complex legal point in this case, other than the tragic facts, is the issue that surrounds whether or not Ms. Sacoolas has diplomatic or had diplomatic immunity and how that might impact on both the extradition and the criminal process. And Georgia, you very clearly outlined the different types of diplomatic immunity in your recent article on our website. I just wonder whether you could help us by summarising the basics of diplomatic immunity and then how we think it applies to this case.
Certainly. In terms of the basics, diplomatic immunity is a key principle of international law which protects the agents of a foreign state from the criminal and in some cases also the civil jurisdiction of the receiving state. And it's important to remember that immunities exist to protect the state, not the individual who actually benefits from the immunity. Now, the foundation of state immunity stems from the principle of sovereign equality. On the international stage, all states are considered to be equals, and therefore no state has the right to judge the actions of another state. This, of course, extends to diplomats themselves, because firstly, they are acting on behalf of their own state. And secondly, if they were liable to be arrested or prosecuted, this would interfere with the ability of that state to conduct international relations. So that's the rationale there. Now, at general international law, the situation is covered, the law is codified by the Vienna Convention on Diplomatic Relations. Now, both the UK and the US are a party to this convention, as are most of the other countries around the world, actually. Under Article 31 of that convention, diplomatic agents enjoy immunity from criminal jurisdiction in the receiving state. And Article 37 of that convention extends that immunity to family members forming the household of the diplomatic agent as well.
And, and I think that's what there's a lot of confusion around that issue is, what is the policy reason for extending diplomatic immunity outside of the diplomats themselves to the family and household?
Essentially, again, it's to do with protecting the state. Now, if family members were liable to be arrested or prosecuted for an offence, this could be used as leverage against the agents of the states, and it would overall impede with their ability to engage in international relations. So again, it falls under that broader policy umbrella of protecting the state itself and preserving its ability to properly engage in international relations.
And I suppose you could see a scenario where a diplomat was in a less friendly state in the United Kingdom, and their their family were accused of a criminal offence and put in prison, and that criminal sanction was used as leverage against the diplomat to provide state secrets to another state or to advantage that state in some way.
Absolutely, yes. It's to prevent any sort of abuse of power like that, and to protect the status of agents in foreign states and allow them to do their job on behalf of their states.
And one thing that we've seen problematic in this case is that, I mean, the Foreign and Commonwealth Office seem to have got themselves a little confused, at least in their PR, as to what status Ms. Sacoolas has. Now, she's returned to the United States and is there now. So that means that she no longer has diplomatic immunity. Is that correct?
Yes. Now that she is back in the United States and her husband's diplomatic functions have ceased, so has her diplomatic immunity. It may assist here to explain that there are two different types of diplomatic immunity that may exist. The first is personal immunity, which would be absolute personal inviolability, meaning that the agent or her family member could not be arrested or prosecuted for any act either committed on an official basis or committed in private. However, this type of immunity attaches to the office holder. And so once the person is removed from office or leaves office, they are no longer entitled to rely on that immunity, and they're only protected for that period that they are in office. The second type of immunity is functional immunity. And this immunity applies in relation to official acts of the state. And it attaches to the act itself being an act of the state, and therefore it subsists even after the agent has left office. So in short, while a diplomatic agent, or indeed their family member, as in this case, is in office, they are essentially untouchable. However, once they leave office, they can be prosecuted for acts committed during their time in office, but only those which were committed in a purely private capacity.
And there's also, I mean, there's some further confusion in this case. There's some mention that Ms. Sacoolas might in fact have been acting in an official capacity and she wasn't just the spouse of a diplomat. And also, as we understand, in fact, because normally under the Vienna Convention, a list of diplomats or consular officials is provided to the host nation, and that is agreed upon between the two states. But in this case, there's a particular type of diplomatic immunity that attached to the base RAF Croughton where they were stationed, and that has added a slight layer of complication because we're not quite sure of the contents of that agreement. Is that right?
That's exactly right. I think for the moment we can only assume, based on what Dominic Raab and others have said in public, that the immunities granted to the RAF base are the same as those as contained in the Vienna Convention. But we are simply making that assumption as the details of that treaty haven't been made public. And so the precise form of immunity to which Ms. Sacoolas was entitled, we can't say for sure.
And we've also seen, I mean, there's been a real problem because there was the extradition request was made to the United States, and the US State Department, we don't know whether it was Mike Pompeo or some other official in the Department of State, essentially said this was an egregious misuse of the system by the UK government. And that was pretty strong language, and also pretty strong language to essentially say we're not extraditing Ms. Sacoolas. And so, I mean, what do you think the chances are of Ms. Sacoolas being extradited to the United Kingdom to face trial?
My personal opinion is that, politically speaking, the chances are slim. For the reasons that you've mentioned, the US have expressed a clear intention that they do not wish to extradite Ms. Sacoolas. However, my opinion is that the legal possibility is there. For example, if she were to travel to a third state, she could be extradited to the UK to face trial here. And were those procedures followed, in legal terms, my opinion would be that she wouldn't be able to rely on her immunity, and that would allow for her prosecution in the UK. In relation to the statement made by the US State Department, it appears to me at least, that they're making this claim as a justification to keep the case out of court. And if the case were to go to court and to be decided according to international law, my opinion is that it would quickly become apparent that there is no legal basis for the claim, that she can still rely on her diplomatic immunity. But of course, again, that's more of a political arrangement than a legal one at this stage.
I mean, I think there's a bit more nuance to it. I think if she was returned to the United Kingdom, there would be real problems with a United Kingdom judge deciding that she didn't have diplomatic immunity, given that so far, as far as we know, the US have asserted that she does, and the UK have also, in some respects, we think either advised her or asserted that she has diplomatic immunity. Although I think, it's, as we said, it's probably a question that we'll never have to answer, because the chances of her being extradited in the current context are pretty slim.
Certainly. I think in terms of the UK's position, that does seem to have changed quite considerably over the last few months. But the fact that the Interpol Red Notice has now been issued does at least indicate that the CPS consider that there is no admissibility bar on the basis of diplomatic immunity, as they would not be able to make the application for a Red Notice to be issued if they considered that to do so would interfere with the UK's international obligations, which would, of course, include the obligation to respect diplomatic immunity. So it appears that that's the CPS position now on whether or not immunity exists. But I agree that the message has been far from clear.
And unfortunately, I think that's one that the United States doesn't agree with.
Indeed.
Well, look, it's been very interesting to discuss this. Thank you all for listening to our discussion, and I hope we can provide you with some more interesting discussions over the weeks to come.